Hi, it's Wendy Hernandez, attorney and creator of Command the Courtroom. So one of the most important things you need to do as you begin your case is getting really clear on what you want. You have to know what you want. You have to be able to express it, because if you can't express it because you don't know, then there's no way you're going to be able to convince the judge or the other party to give you what you want. Another part that is really important, though, is not just knowing what you want, but knowing the reasons why you want what you want, and making sure that those reasons for your request actually support the request. And I know this sounds kind of vague. I'm going to give you an example, though. A couple of days ago, I was in court on a case. I was representing the mother of a little 9-year-old girl, and she and dad had been sharing joint custody for several years over this child, and they'd been doing really well from my client's perspective. They were also exercising an equal parenting time plan. And out of nowhere, Dad served my client with paperwork to change custody from joint to sole. He wanted sole custody. And in his paperwork, he said he wanted that change made because he felt their daughter had been having excessive tardies and absences while she was in my client's care. So we went to court, and I was able to sit down before the court hearing. It was a status conference, and talk with the dad about his concerns. And in my mind, I guess I didn't really understand how too many absences would change if he had sole custody or sole decision making, because decision making or legal custody relates to who's making major decisions in the life of the child. Major educational decisions, meaning whether the child's going to switch schools or not, major medical decisions, major religious decisions, and major personal care decisions. And this tardy issue isn't something that is a major decision. A tardy issue is more of an everyday type situation. And I felt like if he was really concerned about the tardies, then maybe we should be looking at whether, one, the tardies were justified or there was a good reason behind them. And two, if not, then maybe whether a change in a parenting plan would be appropriate. So when I talked with Father about this, he understood, and he agreed with me that there was no fitness issues as far as my client was concerned. He agreed that they got along well and that they'd been able to make major decisions together in the past. So in the end, he agreed that the parties would keep joint decision making. And really, that's the only change he was asking for. He was, in his paperwork, he wasn't asking that he get more time with the child, despite the fact that he didn't like these tardies. He wanted equal time to stay the same, and my client was fine with it. But they sat down and they were able to talk about, the absence situation and the tardy situation, and it turns out there were good reasons for that. And so he was satisfied. So, that's just an illustration of a situation where I think what Father really wanted was assurance that his daughter wasn't going to be tardy, that her school wasn't going to be affected, that she wasn't going to be missing too many school days. And this is an issue really that could have been talked about before he filed the lawsuit, but his concerns really didn't support the request that he was making for sole decision-making authority. So before you file a lawsuit, make sure your reasons support what you're asking for. And as you move through your case, check your reasons to make sure that they set a good tone, a good foundation for you presenting your case. So I hope this little video helps. Like it if you did like it. Subscribe to Command the Courtroom on YouTube. Like us on Facebook. Head to commandthecourtroom.com to check out all the stuff we have on the website. Keep on trucking, and until next week, remember to command the courtroom.